Welcome. I'm Matt Banashinsky, Executive Vice President of the Independent Insurance Agents of Wisconsin.
And I'm Megan Gagas, Director of Agency Services at the association.
We'd like to introduce to you something new we're going to be trying each week. We will be bringing to you via our Spotlight short video clips that will discuss timely topics and emerging issues affecting our industry, as well as some tips and tricks that you can put into practice within your individual agencies. This week, we want to bring to your attention changes to Wisconsin intrastate passenger motor carrier minimum liability insurance requirements. That's a mouthful, but very important. What do I mean by this? Well, recently, the legislature introduced and passed, and the governor signed into law, a bill that would give the Wisconsin Department of Transportation enforcement authority over certain federal requirements and laws. What does this mean? Well, since 1981, the state of Wisconsin and the federal government have had certain minimum liability insurance requirements for motor carriers on the books, but the state lacked the enforcement authority and therefore they were never enforced. Not to mention there was also some conflicting statutes that showed that you could have some lower liability limits, and the rule of thumb whenever you're dealing with the federal government is you have to always meet whatever the federal requirements are. But the state, in this case, never had the ability to enforce those requirements. And as a result, we have motor carriers such as limos, small buses, and vans that have had less than the $5 million or $1.5 million federal minimum insurance requirements. Now, what do I mean? Well, if you're a vehicle that has 10,000 pounds or more of gross weight and has 16 or more seating capacity, you now have to make sure you have $5 million minimum liability limits. And if you have 15 or less and the vehicle has a gross weight of 10,000 pounds or more, you have to have $1.5 million limits. The gross weight is calculated by the weight of the vehicle times the number of passengers at 150 pounds per passenger. And if that value adds up to exceed 10,000 pounds, you're going to need either $5 million or $1.5 million limits. Here at the association, we've been actively engaged with the Department of Transportation and the Office of Commissioner of Insurance on how to get guidance out to our members on how to start to move forward to make sure that their policyholders have the proper insurance in force. And if they don't, how do they go about getting the proper insurance minimum limits in force? We've been working very closely with the department, and I just got out of a meeting late yesterday in which the Department of Transportation informed us that effective immediately, they will begin enforcing these minimum liability requirements. So all of those agents out there that are writing this type of business need to be on the lookout and need to make sure that they're communicating effectively and appropriately with their clients about these new minimum insurance requirements. The Department of Transportation says that the enforcement authority will fall upon either the DMV for when those individuals go to get their licenses or the State Patrol. So both entities have said that they will begin enforcing this immediately. To begin with, we've tried to get some leniency or some grace period for that enforcement period. However, due to some recent story and headlines here in the greater Madison area, metro area, they have decided that it's become too hot of a political football, and as a result, they need to start the enforcement of this immediately. We have asked the commissioner, and they have agreed to put forth a bulletin informing carriers and agents on how to proceed when they are working to get their customers the appropriate insurance limits. So be on the lookout. There will be guidance that will be forthcoming. In addition to the conversations that we've been having with OCI and DOT, we've heard from a lot of our members about how they should be moving forward and the E&O implications. So with me today, I have Megan, who's going to talk a little bit more about that. Megan?
Yeah, when this topic came up, there were a couple issues in regards to E&O that were of concern to me. One was obviously when we don't have this grace period of time to change the limits, a lot of your clients have become illegal overnight. And that is a problem for you because if you're aware of a law or requirement and your clients are running outside of that requirement, there's a good potential for an E&O claim there. So because you have this information, it falls on your shoulders to relay that to your clients.
Good point, Megan. Could you also talk about how now that these motor carriers have to have $5 million limits, how that might impact the limits that our members, our policyholders, should be carrying for their own E&O?
Yeah, that's a great question. Mary and I are both policy administrators here at our office, and we get the question a lot, what limits should I be carrying? That question is really unique to your agency. One of the best measuring sticks that you can take is what's the largest policy that you write. If we're talking property, if we're talking liability, if you write a $5 million building, you should be carrying $5 million E&O limits. If you're writing one of these livery accounts and they've got $5 million limits, you should have at least $5 million limits. It's a little bit different in the E&O world in terms of what you can be sued for. You're typically going to be sued for the policy you should have procured. So that's really a good measuring stick.
Good advice. So if you feel your E&O limits are inadequate, be sure and reach out to Megan or Mary, and they can definitely assist you with that.
Yeah, and I do also think that you'll find the cost to increase your limits is less than you might expect. And if it's more than you expect, maybe you do need to take a look. Maybe you only write one or two of those accounts, and maybe you need to decide if that's a profitable book for you.
Absolutely. Megan, what kind of guidance would you give to these agents as these new laws come out and this guidance will be forthcoming from OCI? What kind of advice would you give to our members on how to communicate these new law changes, to their clients?
Yeah, I would recommend sending out a certified letter, informing them of the law changes and that they need to contact you immediately. But I would also reach out to them over the phone, over email. I would use multiple media services to try to get a hold of them.
Good advice. We're going to have information for you that's contained in the spotlight underneath this video, or that's actually contained right down below. There'll be links to some Department of Transportation websites that I would consider and encourage our members to send out to their clients that may be impacted by this. There's some guidance out there, sort of what are the insurance requirements, depending on the size and the weight of your vehicle, what's the minimum limits that you should have in force. So feel free to click on that link, and it'll provide you with some additional information. We also have a link to the actual act. It's very, very, very sparse as far as details. It's more inside baseball more than anything, but we wanted to at least provide you with that language. And stay tuned to future spotlights, hopefully next week, as we'll have guidance from OCI that will be coming out, helping our agents as well as our carriers understand how to move forward and how to make sure that their clients and customers have the appropriate minimum liability insurance requirements. We hope you enjoyed this segment of our new feature that we will be providing to you in our spotlight. We appreciate you taking the time to listen to our commentary. As always, don't hesitate to contact Megan or I or any member of the IIAW staff with any questions regarding this topic or anything else. Thank you.